So, good morning or good afternoon, whatever you prefer. Preference on this matter is not so important, but preference on words when talking about ethics in medicine is very important. Many words have meanings, many words have implications, have connotations that guide our thought. And I'm going to talk a bit about the choice of words and the importance of terminology. Let's see if I can master the technology here first. Yes. We have a lot of examples in medical ethics of words that contain persuasion built into themselves, and words that should be used with great care, or at least keen awareness that there are implicit sort of messages in the way we use language. In the obvious case to discuss today is, of course, end of life, dying, suicide, self-chosen end of life. There are so many different ways of expressing this, and it does matter what words we choose. I will keep, however, this question in limbo for a while looking at a couple of other cases in medical ethics which illustrate this question about the importance of language. The first one is abortion. Everyone who has followed the American discussion about that knows that there are two terms that every American understands: pro-life and pro-choice. The pro-life people are those who essentially oppose abortion, and the pro-choice people are in favor of some form of abortion. Of course, both positions have different nuances. There are different versions of both positions. There are soft and hard and tough versions of them. But unlike the situation in Europe, nobody would in America understand an advocate of choice to be speaking of other policy issues. Pro-choice has a very distinct meaning, and pro-life also. Now, my second example of the importance of language comes from the EU Charter of Fundamental Rights. Mind you, that is not the European Convention of Human Rights that Dr. Garland just talked about. The the European Convention of Human Rights, that's a Council of Europe document, whereas the EU Charter of Fundamental Rights is a European Union document. This charter was established 16 years ago, and I had the privilege of representing Sweden in the convention that went about formulating. It took 1 year to discuss the different articles in this charter. It was very complicated, and it turned out that every single article was controversial. In fact, the first chapter of the charter has the title Dignity. And that was inspired, in fact, by the German Constitution. In the German Constitution, the first article speaks about dignity. So this was imported into the European Charter, the EU Charter of Fundamental Rights. And the second article was the topic of a very heated fight, I would say, between those who wanted to speak about the right to life or those who wanted to speak about capital punishment. The whole idea of the article was to say, no capital punishment, no death penalty in Europe. But there were two ideas of how to formulate this. Either to say everybody has a right to life, and the other was to focus on death penalty. The problem with the first sentence, the first version, was that there was a widespread fear that this might be interpreted as a ban on abortion, that the fetus also would have a right to life. So it took literally months to discuss this matter, and there was strong interest involved. The Vatican was very active. There were a number of other parties taking taking part. And eventually, this quarrel ended in a not too glorious compromise, which you see in front of yourself, which was to say to use both formula. The article was called Right to Life, but then it was said, yes, right to life, but then to make clear what it was all about, the death penalty, the capital punishment thing was added. So this was an example of how ethical terms can be very burning, very hot in political discussions. My third example is comes from the Swedish Constitution. I was also at one stage involved in the review of the Swedish Constitution in 2004-2008. And one thing we found there was that there had been a little addition to the Swedish Constitution in the early years of the last decade. Inspired by the WHO, there was in the WHO a famous conference called the Alma-Ata Conference on primary health care, where the slogan "Health for All" was sort of launched. And that had a very strong impact, and there were people in many countries discussing how can we implement health for all. And in Sweden, one of the results of the Health for All declaration was to have this into the constitution, injected as a right to health. The problem was only that the Alma-Ata declaration was about primary health care, basically. Whereas when we in the Swedish Constitution said that everybody has a right to health, of course, get the meaning health in Sweden doesn't necessarily mean health care, it means hälsa. Guaranteeing everybody a right to health would sound like a promise of eternal life. So there was a certain feeling that this was not perhaps the best way of rendering the meaning of the WHO recommendation. And after having discussed this for a while, there was unanimity to take this away and to soften somewhat the guarantee. The state would no longer guarantee eternal life, but would only guarantee good preconditions for health by the various sort of measures that we take by public, through other public services. So this, again, another example of the fact that terms, even if very familiar terms, may not always mean the same thing as you expect. Even the word rights, I would like to add, turned out to be extremely ambivalent. In this convention that discussed the EU Charter of Fundamental Rights, there were a number of different views from different countries about what a right really meant. Could you have a right even if you didn't expect to respect it? I mean, could you have a right? Well, some people said you can have a right. It's a goal. It's a distant objective, but by calling it a right, you nevertheless emphasize it. Others said, well, we are very serious about rights. If we recognize something as a right, then we want to be sure that we can deliver. These were some slightly different views, a bit South Europe, North Europe in the cleavage. The Spaniards had derecho al trabajo, but also the biggest unemployment in Europe. So finally we tried to agree on a common use of the word rights, but there was an addition of principles. Sometimes when the right could not be guaranteed, the convention decided instead to speak of principles. So as to soften somewhat the promise from the European Union. So these are some examples of how word problems crop up in ethical and legal discussions. Now back to the terminal decisions. Even the word terminal decision is of course a bit tricky because a completed suicide is preceded, you can say, by a terminal decision, but in the case of attempted suicides, the term does not seem appropriate. I mean, you cannot have a lot of terminal decisions along your life, even if you attempt suicide many times. Suicides attempts, as we know, are often cries for attention, help, and care. Fortunately, most attempted suicides are not terminal. So the word terminal decision is a bit tricky. We also have, of course, the version suicide or self-chosen end of life. Suicide, let me say that first, that suicide is, of course, a Latin word. It is the normal English word now, although English has also self-murder. Swedish has self-murder as perhaps the main term, whereas suicide also exists, of course, but it's more of a medical term. And I think the coexistence of the two terms illustrates something that the English language shares with medical language, in that you can alternate between a kind of vernacular, national, sort of domestic, Anglo-Saxon, Teutonic, Germanic way of expressing things, and a Latin way of expressing things. When doctors go into Latin, they can express themselves with less emotions, it seems. When we turn into the popular language, then the implications are quite often more brutal. Self-murder, that sounds more brutal than suicide. And we have a similar sort of effect, I think, in other cases where Latin and more sort of Anglo-Saxon, Germanic, Teutonic versions coexist. So my personal preference now is that I would reserve the word suicide for dramatic actions by healthy persons who are not about to die anyway. But I would not speak of suicide when talking of patients who are incurably ill and who are suffering unbearable, intolerable pains. When such persons express an autonomous, repeated wish to die and convey it to more than one physician, they should have the right to do so, if necessary, with medical assistance. So that's my personal view of how the words should be used. Of course, palliative care are extremely important. Suicide prevention also are important. I would not go as far in my support for autonomy as to say that anybody expressing a desire to die should have his or her way. When it comes to young people who are desperate, all kinds of people suffering from psychological problems, one should, on the contrary, go to great lengths to try to convince that person of other possibilities. But under certain conditions, the exit option is clearly legitimate and should be respected. I would add that demands for the exit option should be contained through palliative care, first of all, and through suicide prevention efforts. So that's my personal conclusion on the use of words in this very difficult domain. Thank you very much.
Thank you, Professor Tarschys, for most thought-provoking presentations. Words do indeed matter. We will now open the floor for discussion. I'll move. Presentations have given plenty of food for thought and, of course, given ideas and raised many questions and points of discussions. And I will now open the floor for questions to our speakers. And it would be appreciated if you could introduce yourself.
Staffan Danielsson, parliamentarian. Very interesting all day and now. To you, a question about Swedish laws contra European laws. You said it was somewhat unclear in certain aspects. Very interesting. Could you just clear that shortly again?
Well, I think under criminal law, it is clear that suicide is not a crime in Sweden. That is clear. And the cases are quite clear that we've had in the courts saying that if somehow the pills are legally prescribed or are given by some other measure, it doesn't matter, I guess, how the pills get to the family member, but the pills are placed in the mouth of a patient and the patient swallows. The patient's making the determinative decision, the act that's required to carry out the end of life. The problem comes in when someone takes an active step to hasten death. And so even though the providing of pills in the mouth would seem like an active step from a criminal perspective, it does seem to me, the swallowing, the ability to spit out the pills seems to be a determinative one. If the patient could not spit out the pills and the person really forces the pills down the throat, I think you'd have a very different case. So as a criminal law, that's the line we have. The bigger problem is medical law, perhaps, number one, under Swedish law, or maybe it's not a problem, it's good, depending on one's point of view, is that our medical law is designed to say that the obligation of clinicians is to treat illness and injury. And clinicians are authorized to do that, and again, to make sure that there is science and well-tested experience to support those decisions. The converse of that when it comes to dying is that if potential treatment will not help a patient, there's no obligation to provide futile care. And in that sense, withdrawing care is not going to subject the clinician to any liability, nor would withdrawing life support be a problem if the patient says, stop it, you're giving me an intervention that's keeping me alive and I don't want it. The patient's consent must be respected, which also is consistent with the European Convention of Human Rights. There have been cases usually involving detainees, people who are in prison, where in some of the older cases, the court was very open to the idea that you could force feed someone or use an injection on someone, but the court has been very, very reluctant to make those arguments outside of detention context because people are under the direct care of the state when they're in prison. The court has said you can't let strangers come in or med students come into a hospital room while you're examining a patient, even if you're not doing a physical intervention and who is getting a gynecological exam. You have to respect the patient's consent. If the patient, any treatment that is forced, that is non-consensual, that creates fear in the patient, or any anguish, that is degrading treatment. It's true under many international human rights conventions. So Swedish law is very consistent in that regard. Where it becomes, again, unclear under medical law is whether or not you can give pills, prescribe pills, without clear guidelines as to how they should be taken, or with advice. This is how many you should give, so that your loved one will die. It's unclear. That's not authorized by Swedish medical law. It's not authorized to take any action to hasten death. That's just not authorized. We authorize, this is the bound between medical law and criminal law. Medical law gives great discretion to medical authorities to supervise clinicians on the grounds that we trust that clinicians exist to treat illness and injury. I think the difficulty for clinicians in these situations is when you have someone who is going to die and is clearly suffering. And the question is, how long will this go on? And if the patient can say, I would like for that to end, this is where it's unclear that the physician can do anything to hasten that, because there's not specific authorization, which is again why when you talk about what's the next step, You have to have an adequate framework in place to make sure there are rules and guidelines as to when this can occur and when it cannot occur, to protect the clinician, to protect the patient. And that's what's unclear. Again, the European Court of Human Rights gives very broad guidelines in these cases, and especially will for active assisted dying. There is no consensus, and the court does not make law without cases coming to the court. So unless we get a law, or unless someone in the Netherlands or Belgium challenges the framework that exists in those countries, we're not going to get the court to give an opinion on the Dutch law or the Belgian law, unless someone says, I don't know if you saw the news this past week, but someone in the Netherlands who is a chronic alcoholic took advantage of the assisted dying measures in the Netherlands, and with the consent of the family, and it was a big discussion. He just said, I can't go on. But if the family members were to object and said that there was not a framework, we couldn't go to court, we couldn't get protection, then the framework would be challenged. And this is what's unclear in Sweden. Our lack of judicial review for people, any patient who says, you are torturing me with treatment I do not want, the chance to go to court and say, stop. The lack of judicial review when there's a proxy consent and we don't have a framework to recognize it. The lack of a framework to make sure that family's input is taken into consideration rather than the doctor or a second opinion being the ones who have to make the difficult call that this patient is suffering, and these are the problems which are very unclear from a human rights perspective.
I'm Ingemar Engström. I'm a psychiatrist as well, and I thank you, Daniel, for putting the emphasis on the necessities of using good wordings. But I would challenge you on 2 points. You said that suicide is about something that healthy persons would like to perform. I would challenge that. Suicide is very closely associated with depression, at least in 9 cases out of 10, I would say. So it's not about healthy persons wanting to die. And about the second conclusion, you would like to use the word wish to die. I think that's not empirically supported in this branch. When you have studies of people asking for assisted dying, it's not a wish to die, actually, that is putting the process going. It's a people who, due to serious illness, cannot any longer fulfill their goals in life. It's about people with a low or very low quality of life. It has mostly to do with feeling of loss of control of what will happen with me in the future. It's about loss of dignity. It's not about the wish to die. That's another thing.
I accept both your objections. I did not really wish to be very sort of definitive in what I said about when I use the words. I was mainly interested in saying I do not want to use the words in certain contexts. I do not want to use the word suicide when it comes to elderly people who are suffering from intolerable pains and who have incurable illnesses. That was my main point. I'm rather for pressing away the word suicide to a very limited field of use. And if you want to press it even further, fine with me.
This is just a follow-up question to Daniel. Not using suicide. Now you propose the term "wish to die." Perhaps not so good, you said. So what should we call? Do you have any recommendation for us? 10 years ago, Smer used the term självvalt livsslut, self-selected end of life. Is that a term we should still use, do you think? Assisted dying? Well, that's what I guess all palliative care is about, really. So there is room for confusion. Assisted death? What should we use?
I wish I knew, but I have no definitive convictions on this. What I have definitive convictions is that we have been abusing the word suicide for situations which are not really suicidal. And particularly with the brutal tone of the Swedish word självmord, self-murder, it comes out very, very badly, and it tends to sort of make the discussion very primitive about situations that need to be analyzed and discussed with much greater care and much greater compassion. So my main message would rather to distance myself from the excessive use of suicide for certain kind of situations. Then as for the fine tuning, I have no definitive proposals to make, but I think the discussion about this is important. We need to continue looking at the language side, the terminological side of this issue, as well as the more substantive philosophical aspects.
To offer something, I mean, the Council of Europe, the Committee on Bioethics of the Council of Europe, includes these discussions under the general category of medical assistance at the end of life. And maybe one could ask the question as to whether we need a specific term for what passive or active actions to have the conversation. I think the general category of medical assistance at the end of life, if it includes, taking measures to help the patient sleep in the last hour, but also includes maybe taking some additional measures. We don't often get into details of the specifics of medical treatment. Maybe for the discussion, I think it may be important to have the specific distinctions after we get into it, because the debate will have to take up those specific questions of active or passive conduct. But the general category, the starting point, is medical assistance at the end of life. And this is what we're talking about here, as to whether medical professionals can, I think, engage in it. And that's the starting category, which is much more neutral, at least from the Committee on Bioethics point of view.
Thank you.
Anna Lindblad. I'm a psychiatrist, so I'm kind of used to using the word suicide. It's probably the word I used the most every day. I'm kind of fascinated of the reluctance against using the word suicide. I think we should rather question why we are so against it than start finding new words. Isn't it that we are so scared, there's so much stigma around mental health problems and around suicide that we don't want to use these words in other contexts? Because the act itself, in taking drugs that actually end your life, that is suicide. So why is it such a reluctance against this word? And that's a thing I think we should actually think about. And the reason why I am kind of in favor of using suicide is that it is clear. It says what the action actually is, instead of talking about självvalt livsslut or something else which is rather unclear. Yeah.
We are a bit handicapped by having this discussion in English, but the real object of my resistance is the word självmord, self-murder, which has this component of murder in it, and which has, of course, a very strong stigma for good reasons. Murder is something horrible, and I think it's plain wrong to allege, to contend that people contemplating suicides are contemplating some form of murder. I think the murder term is extremely misleading and should not be used in that context. Suicide, the English term, the Latin term, is more benign, is more clement in many respects than the self-murder term, and is preferable to the self-murder term, I think, for everyone.
Thank you.
I'm Torbjörn Tännsjö still. Just a comment on terminology. Again, I agree completely with Anna there. And when you speak of suicide, of course, suicide, not självmord, not self-murder. And then we have also a very useful Swedish term for covering both euthanasia and physician-assisted suicide, which is the title of Wayne's book, Assisted Death. I had problems first with finding a Swedish title for it, but then it occurred to me that we have this very nice word, dödshjälp, which I think covers it. And it's plain speaking, again, like assisted suicide. But then to Jameson Garland's comments here, I think it's really problematic that it's so unclear what the doctors are permitted to do. We had this Astrid Lindgren case, for example, and very strange pronouncement from the prosecutor, and now it wasn't really found out what the legal realities are here, but and also some professors in law are concerned here that our legal situation isn't it's far from perfect. But more particularly, I would like to know more about this medical law, relying on this beprövad erfarenhet. We have lege artis, perhaps also as a term for, or just practice. Isn't it really? Doesn't it boil down to really what doctors do and what they condone and what they condemn? And so we had, for example, a situation around 2000 where terminal sedation was considered against lege artis and a criminal offense really by experts. But now it's part of medical practice. And what has happened when doctors do it, and more important, people say that it's possible to do it. Experts condone it. So then I'm curious about this physician-assisted suicide. If people start to do it, if you dare do it, Per, and risk your license, perhaps, couldn't one mold the practice by just trying it out? Well, Elisabeth doesn't think so, but I think we should give it a try, or you should give it a try.
Do you want me to answer the question? Well, as a general rule, we also know what the problems. First of all, we have an investigation going on the boundaries between clinical practice and research for this very reason. I think all of us in this room know what happened at Karolinska, but in the Paolo Macchiarini case, and maybe that answers the question. I mean, the question whether we can allow experts to decide or practice to evolve is a problem. Is Niels Erik here? Niels Erik Salin? He's not here today. We have a whole project that's actually going on in Sweden to flesh out and develop this term, vetenskap och beprövad erfarenhet, because it's been, how do I say this, not very well clarified in the preparatory works and the legislation. But I think, again, I'll take cues from my former mentor, or ongoing, forever mentor, Elizabeth Rinning. And what I say in my own work is that vetenskap och beprövad erfarenhet was never intended to have this universal application outside the context for which it was created. It was designed to create a threshold for when care was safe and effective to be entered into clinical practice, that it's consistent with medical science, and that it is consistent with well-tested experience. We don't use experimental treatment in healthcare for that reason. In the kvacksalverilagen, the förbättringar för kvacksalverilagen, the government was very, very clear that that lege artis is no more. We are not artists in medicine, we are scientists. And so they don't like that term and the idea that practice simply evolves purely through experience. It has to be science-based to determine when treatment treats an illness or not. And that's what it's used for. When we start talking about when science runs out, when science has no more solutions, when science has no cure, that's a sign. Stop. The sign that science is telling us we're no longer in the realm of science. And I think this is where we have several areas of law that are especially authorized where we're not talking about treatments and cure for illness, where the scientific character of what we do is more amorphous. But we have special legislation for that. elective procedures such as terminating a pregnancy when it's not necessary for healthcare. It'd be considered important as a right. It's one of the few laws we have that records a right in Sweden in Swedish healthcare. We have a sterilization to prevent reproduction. That is specially authorized. We have legislation for assisted reproduction for people who have gender distress, where that's a very touchy area for doctors to be diagnosing someone's gender. And I will say the Committee on Bioethics is discussing this question as on this very question of whether or not this is a scientific question, but it's a rights question. It's a question of someone's right to die with dignity. If they don't want to continue treatment and they're suffering, that's a rights question. And this is where law does have a role to play. It's not a question necessarily of a medical scientific judgment. Someone is in fear or anguish. They do not want the tubes put down their throat. That is a legal question because it deals with an emotional, juridical interest that's not purely a scientific one. And when doctors, I think that the talks we had this morning were very, very passionate about this question about the difficulty of judging someone else's suffering and the need to die. Is that science? And vetenskap och beprövad erfarenhet can't tell you when is someone suffering. It can't do that. So the question is, the solution is not to worry about breaking up vetenskap och beprövad erfarenhet and going back to lega artis. It's about asking, do we have special legislation that respects the patient's consent, that prevents degrading treatment, that can make determinations as to when we as a society have decided that we want to help someone die with dignity. Make it clear, give legislation to give clinicians the room to do that, make sure it's consistent with our human rights obligations, judicial review to make sure there's no error, and to clarify it. But to deviate from, look, Sweden is, in all of Europe, and in all the world, as far as I know, this is something we need to take more pride in when it comes to vetenskap och beprövad erfarenhet. We have had a standard of care in Sweden that is based on science and well-tested experience going back to 1890. And most of European countries do not have that standard. It's loose, and it's left to professional judgment. And I think that we in Sweden could take pride in the fact that when you look at things such as the treatment of women in the late 19th century and why we didn't do things to women that were done in other parts of Europe, because our doctors, our gynecologists were more concerned about the scientific risk of removing the uterus or ovaries of a woman, that's when we were ahead of the world on that. Where we have fallen from that is in all of our scandals, whether that's the sterilization controversies, whether that's in the Paolo Macchiarini case, these other cases. So we need to take pride in the fact that our healthcare, providing care, is based on vetenskap och beprövad erfarenhet. These other questions where science has no answer, then we have to ask, do we have special legislation so that doctors can give medical assistance at the end of life and do that in a way that protects patients' rights and protects the clinicians from discipline? That's my point.
Okay, thank you. And I think with this we'll have to put an end to this discussion, and I'd like to thank both our speakers. Thank you.